with what's that? Oh, by the wife, my lady, I'm sorry about that. He does not show how the 50% were shared off, and now the shares that he's offering as a bail, how sure are we of their worth? We might end up holding on to a worthless share certificate if he contends what we're stating to you, that ISA Global is a very company which has assets, including the house that he's staying in, is owned by that company. Now, if he disposes of those assets, if he disposes of those shares, we're going to be left with a worthless share certificate as bail. He can easily do that. My lady, we showed to the court that having been born in England, he spent half of his life outside of before he came into South Africa, under correction, and land friends can confirm he came to South Africa at around age 27. It appears from his CV that he went to school in England, in India, Swaziland, Pakistan, the United States, and here in Johannesburg. Attended university in California and Wisconsin in the United States. He says he took post-qualification courses in California and Connecticut in the United States. Was employed in Los Angeles, Oakland, Chicago, and even in the United States before he came to South Africa. He speaks English, French, Urdu, and Hindi. He thus, my lady, has international connections and families outside the borders of this country, like he correctly states in his affidavit, and we can confirm that he has a brother, Yusuf, and a sister, Leila. And Leila is working and stays in the United States. And he wants to give an impression to the court that most of his traveling in and out of the country were, among others, work-related when he was working for government in the DTI. That is correct, my lady, because the accused left the employment of the DTI in 2010. And the records that we're referring the court to regarding his traveling is between 2010 and 2021, at least. Therefore, after having left the department, he traveled a lot still outside the country, and therefore it is not true that he was traveling due to work commitments. My lady, the finalization of the case against the accused does not depend on the extradition of the other people that we mentioned in the indictment. And as correctly pointed out by Leonard Friend, investigations in this matter are completed. We are ready to disclose the case docket. The moment we finalize the bail applications, we're going to hand over the case docket to the colleagues and arrange a trial date. Therefore, we are ready to proceed with accused 1 up to 5, and next week we'll be adding the last accused in the matter, Mr. Dinesh Patel, whose name was mentioned in the other bail applications. And the rest of the other accused or suspects, as they appear on the list, are currently outside the borders of the country, and we do not intend to waste the cost time regarding extraditions before the trial starts. The trial is going to start with or without them, and my lady, if they were to be extradited before the trial starts, we'll add them. But that does not take away the fact that we're ready, and the starting of the trial does not depend on their availability. My lady. They can always be tried at a later stage. They are not currently accused before court. They can only be added to the charge when they are available. But the starting of this case and finalization thereof does not depend on their presence. We have checked his movement in the last 10, 11 years, Malidi, just to give the court an indication of who we're talking about. The accused frequents, in Africa, he frequents Addis Ababa in Ethiopia, Accra in Ghana, Beira in Mozambique, Brazzaville, Congo, Cairo in Egypt, and Uganda. He travels a lot to Botswana, Harare, which is in Zimbabwe, Kampala in Uganda, Lagos in Nigeria, Zambia, in Maputo, in Port Louis in Mauritius, Nairobi in Kenya, the Seychelles, and Namibia in Walvis Bay. In Asia, he visits Dubai in the UAE a lot, Abu Dhabi, Bangkok in Thailand, Doha in Qatar, Hong Kong, Istanbul, Mumbai, India, and Singapore. We picked up one trip to Australia at Sydney, frequents Europe, in Amsterdam, the Netherlands, Frankfurt, Germany, London. It's not amazing because he was born there in the UK, born in the UK, not that in London. Then friends should not assume that I'm saying he was born in London. In France and Switzerland. He visits the North America, which is Atlanta, in the USA, and in South America, he visits Sao Paulo in Brazil. He's made a lot of connections in many different countries. If he skips bail, where are we going to find him? My lady, I respectfully submit that we have covered all the grounds that relates to the Section 60, subsection 4, D and B, and we have managed to show to the court that the accused is a flight risk and that there's a likelihood that he might not stand trial if given bail, and that if he were to be given bail, the administration of justice will be brought into disrepute in the event that the accused absconds. We have in our documents showed a number of bank accounts which he possesses, some of which are supported by learned friends, and that this is a man of means who can easily travel anywhere, anytime, my lady, and that he can afford to forfeit the amount of 100,000 which he suggests as bail. I therefore, my lady, respectfully submit that the state has managed to successfully push the grounds against the application of bail by Mr. Sharma, and request the Honorable Court to turn down his application for bail, and that the accused should be kept in custody, by lady, until the finalization of this case, in that if all the facts are weighed up against his personal interest and his right to be presumed innocent, by lady, the interest of, he has failed to show on a balance of probabilities that it is in the interest of justice that he be released out on bail. Unless if the court wants to hear me on other factor. Thank you.
Thank you. Your Worship, I've also produced some heads, which I would like to hand to you. I'll also give a copy to my learned colleague. Your Worship, I must first of all ask you to excuse the fact that the references to Colonel Moloto's statement was based on the first statement that was presented in the other matters. That was initially given to us. So I would ask you to ignore that references, but I've not had the time to adapt that to the new references. But you Worship, will find it, and I'm sure know the record, if I may hand it up. Your Worship, I am going to deal with very shortly with three matters that was raised in argument. The matter of ISA Global and the allegations of the money that was paid into that company the allegations referred to 2016, that money was paid in there. The state has not produced any bank account or proof that money is still in that company. And if they are confident about the money that they say that's in the company, we pledge their shares to them. They can take it. They can have the company, because we are confident that there is no such money. But the value that there is in the company is, for example, the house and the immovable assets that it owns, and for that reason we pledge that to the state. Your Worship, then a further issue that they say that really one cannot just glance over these allegations, to say that the United Emirates residence card, that if we hand it to them, then he can just go there and enter there. If he doesn't have a residence card and he doesn't have a passport, how does he get into the United Emirates? And for that reason, one cannot just make an allegation that, regardless of the fact that it hands it in, it doesn't matter. And then the fact that the state now say that they don't need the Guptas in this trial is a bit of a knee-jerk reaction, because they cannot really explain, or they do not want to deal with the time delay in the extradition. They have added on the charge sheet the Guptas and the external companies and the international people. They have put it on there. And it's cold comfort for them now to say, but they don't need them in the trial, they can continue without them. It is respectfully submitted that they decided to join them, and they will do the extradition. I'm going to refer you, Worship, to my heads just on page 7, paragraph 8, and I there referred to the appeal court decision of S versus Van Wyk, which says that the court can consider whether there's a prima facie case, but the court must not make a provisional find of guilty or innocence. Now, the state is arguing this matter as if it is set in stone, the accused are already guilty, and that is why he will abscond. And that the law clearly states that is not the way to approach this. And in the Bronco matter that I referred to, it is the freedom, and the courts deal with the rights to freedom in the Constitution and guard it jealously, as I've set out in the quotation. Then over the page, it is indicated the court will always grant bail where possible and will lean in favour of and not against the liberty of a subject. And then obviously the well-known matter of Akerson in paragraph 9, which says that we must guard against the detention pending trial as a form of anticipatory punishment, and we must, and that goes back to the presumption of innocence. In the Dlamini matter that I referred to in paragraph 10, what is important here is, and I've underlined that the important proviso throughout is that there has to be a likelihood, i.e. a probability that such a risk will materialize. A possibility or suspicion will not suffice. And I respectfully submit that the state has done nothing to cross that hurdle from a possibility or a suspicion. They have not crossed that. They are still before court with a possibility and a suspicion that he will evade his trial. Thank you.
Your heads of argument, Exhibit J.
Please.
Insight into the affidavits, very lectures last night. And supplementary affidavit of the applicant was handed to me before we started today, so I also had insight into that. I also heard the arguments presented by the defense and the state, and I'm ready to proceed with my judgment. You may be seated. You don't have to stand for this purpose because it is selected. The applicant is applying for bail. He is charged with Schedule 5 offences. The allegations of fraud and money laundering amounting to over 24 million rand. I received 2 affidavits from the applicant in this application. He did not present any other evidence. The state indicated that they are strongly opposed to bail. I received affidavits from the state as well, compiled by the investigating officer who is the court. I'm going to deal with the affidavits of the applicant first. The affidavit of the applicant briefly contains the following information. Is everything good in it? The applicant is 54 years old. He was born in the United Kingdom, and he is a South African citizen. He has a United Kingdom passport. He is self-employed. He was previously employed as Deputy Director at the Department of Trade and Industry in South Africa, and therefore he travelled frequently. He is married according to Islamic rights. His wife is a permanent resident in South Africa, and she is not dependent on him. They do not have any children. His siblings are in the USA. He's been aware of the ongoing investigations against him for more than over a year. Even after he became aware of it, he still travelled abroad and returned back to South Africa. His parents are deceased. It is the first time that he's been charged with the offence. He owns fixed property in South Africa. Most of his assets in South Africa have been touched by the asset forfeiture unit. The final forfeiture of this depends on conviction. He undertook to stand trial and indicated that the state's case against him is strong. He cooperated with the investigating officer and the State Capture Commission. The investigating officer stated in his affidavit that he is of the opinion that there is a strong case against the applicant, and the applicant is a flight risk as he has connections where he went to school and the USA where his siblings lives. He was previously employed in the USA before he came to South Africa in 1994. He owns a company, Isar Global Limited. Through this company, he has access to hundreds of millions of rands. The property commonly referred to as the top billing property is owned by Isar Global Limited. This property is in Morningside, Sandton, where the applicant and his wife resides. Isar Global Limited is a company incorporated in the UAE. Investigations revealed that 2 South African companies, MAR Shipping Limited and Woodview Corporation Pty Limited, transferred about 265 million to a bank account, that's now million rand, to a bank account held by Isar Global Limited. Investigation also revealed that it was for falsified transactions, leading to the conclusion that Woodview was used as a money laundering vehicle. He has access to his offshore First National Bank account, his Noor Islamic Bank,
account and his first Abu Dhabi bank accounts. The IO further stated that he has the financial resources to flee the country. Due to the fact that the applicant is extremely wealthy, he can afford to forfeit the amount of bail fixed. The investigating officer motivated this remark in detail in his affidavit, and I'm not going to deal with this detail in my judgment. The investigating officer concluded that he is likely to flee to the UAE because of different reasons. Number one, his interests and the company ISA Global and AXA bank accounts in the UAE, offshore assets in the UAE, especially in Dubai, running into hundreds of millions of rands. Secondly, as the investigating officer called it in his affidavit, his partners in crime, Gupta and Issa, who are also in the UAE, in Dubai. Thirdly, the travel records showing that he made over 100 flights to or from airports in the UAE since 2010. He has residence rights in the UAE. That was the fourth reason. The investigating officer further stated that if he flees to the UAE, it will be extremely difficult to extradite him, as the National Prosecuting Authority has experienced very poor cooperation from the UAE relating to the investigations into ISA and the Guptas. This is also further motivated in the affidavit by the investigating officer, and I'm also not going to deal with that in too much detail. The investigating officer is of the opinion that his case against the applicant is strong and indicated that he is being investigated in a range of more serious cases of fraud and corruption for which he has not been charged yet. If convicted, the applicant will face at least 15 years direct imprisonment on one of the fraud charges or the money laundering charges in this matter. The state relies on the following subsections in the opposing the bail. Section 64, the interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established. The likelihood that the accused, if released, subsection B, will attempt to evade his trial. That is the main reason. And then subsection D will undermine the proper functioning of the criminal justice system, including the bail system. After considering the evidence that was presented by all parties, I find that there is a strong case against the applicant, although not all the finer details of the evidence against the applicant was presented. I know that if there was not a good prospect of success, the DPP would not have indicted the applicant for trial. Therefore, there is a real likelihood that the applicant, if released on bail, may attempt to evade his trial. The defense argued that he could have fled already if he wanted to. That is so, but we do not know what motivated him to stay up until now. As correctly pointed out by Advocate Sourenier for the state, this is the first trial flowing from the State Capture Commission inquiry. It is not uncommon in criminal trials for accused persons to sit their trials out until the end and then to disappear just before judgment when they realize that the evidence presented is overwhelming. He has the incentive to evade trial due to the lengthy period of imprisonment that must be imposed if he is convicted. He has the financial means available to flee. The fact that he can be traced if he flees is no consolation. because it would entail that the state will have to go through a very long, costly and difficult process, which can take years to bring him back to court. The applicant has nothing keeping him in South Africa at all. His most valuable property in Sandton is registered in the name of his company, which is in the UAE. The other property of value is in the process of being sold. He does not have much money in his South African bank accounts. No amount of bail that the court can fix today can secure the court attendance of the applicant. The fact that the passports in his possession can be handed in does not really mean much. False passports and travel documents are a reality in South Africa. People illegally crossing borders in South Africa without documents are also a reality. It is in the interest of justice that offences like these be prosecuted and for a court to bring out a verdict in the end. The longer these criminal processes take to be finalised, the greater the risk that it will never be finalised because of the fact that witnesses pass on and memories fade and evidence disappear. The final forfeiture of the assets attached is also dependent on a conviction. If the accused persons are given bail and they cannot return to court, the state will find it very difficult to bring these cases to finality, especially in cases like these, where there are going to be at least 16 accused and many witnesses with complicated evidence. The state addressed me and indicated that the investigation is complete. They do not have to wait for the other accused to be arrested. They can continue without them and fix a trial date as soon as the defence is ready to proceed. I find that the applicant did not satisfy me that it is in the interest of justice for him to be released on bail. I find further that the state presented sufficient evidence to prove that it is not in the interest of justice to release him on bail. Bail is refused.
Just a conclusion. The case against the other accused has been handed to 5th of July. 5 July. May the matter against Mr. Sharma also be remanded to that date.
Thank you, Bishop. That date is fighting resolution. I might not be appearing on that date. Clearly will make that.
Thank you. And Mr. Sharma, your matter is now postponed until 5 July. That is for further investigation. And you are in custody until 5 July. Thank you, sir. You may stand down.
We'll be in the office for a J7.
Have you prepared?
She's still gonna hide.
What's the name?
I